Assalamualaikum warahmatullahi wabarakatuh. Good morning, ladies and gentlemen. First of all, I'd like to thank you to all of you to making an effort to attend today's presentation. Allow me to introduce myself. My name is Salsabila Ivana Surya Putri. I'm from Universitas Pancasila, an undergraduate student of the Faculty of Law. Today, I will present the topic I have chosen, which is criminal law in Indonesia. Introduction: Indonesia is a state governed by law that upholds the justice and legal certainty. These principles is stipulated in Article 1, Paragraph 3 of the 1945 Constitution, which assert that all aspects of national life must be based on law, not merely on power. As a state governed by law, Indonesia regulates various aspects of societal life through a legal system that includes criminal law, civil law, administrative law, aiming to create order, justice, and the protection of human rights. In this presentation, we will discuss definition of criminal law, the difference between criminal law and other type of law in Indonesia. Additionally, we will also cover the challenges in criminal law and briefly present some case examples. Next, what is a criminal law? Criminal law in Indonesia is a brand of law that regulates action considered harmful or threatening to public order and safety. It defines prohibited behaviors, establishes punishment, and ensures justice is maintained by prosecuting offenders. The primary legal foundation for criminal law in Indonesia is the Indonesian Penal Code, or we call it KUHP, which is influenced by Dutch colonial laws and has been adapted to align with the country's contemporary legal and cultural context. Next, what is the difference between criminal law and other type of law? Criminal law, civil law, and administrative law in Indonesia have different focuses and objectives. First, criminal law regulates action deemed as a crime and imposes sanctions such as imprisonment or fine on offenders. Next, civil law governs relationship between individuals or legal entities, aiming to resolve disputes through compensation or contract settlement. Likewise, administrative law regulates the relationship between individuals and the government, with administrative sections such as the cancellation of permit or revocation of right. Next, we have key element of criminal law. First, criminal act or actus reus, causation, criminal intent or mens rea, and concurrence. Next, we have types of crime. First, crime against person. This includes offenses like murder, assault, and kidnapping which directly harm individuals. Next, we have crime against property. Example include theft, burglary, and arson, which is involved with interference with someone else's property. Next, crimes against society. These are actions that disrupt public order, such as drug trafficking and terrorism, and less white-collar crimes, non-violent crimes committed for financial gain, such as fraud, embezzlement, and insider trading. Criminal law in Indonesia. First, the legal basis of criminal law in Indonesia consists of various sources that forms and regulate the criminal justice system. Here are some key components that serve as the legal foundation for criminal law. First, KUHP, principles of criminal law, other legislations, substantive and procedural criminal law, and less general principles of criminal law. Next, here are some examples of cases related to criminal law in Indonesia. We have corruption case, murder case, cybercrime case, narcotic case, theft case, gross human rights violation case, defamation case, and sexual violence case. Next is advantage of criminal law. Criminal law plays a vital role in maintaining order and justice within society. Here are some of its key advantages. First, maintain public order and safety. protect individual rights and freedoms, deterrence of crime, provide justice for victims, rehabilitation and reintegration, promote social harmony, and last, prevent abuse of power. Next, we have the challenges of criminal law. Criminal law, despite its critical role in maintaining order and justice, faces several challenges that can hinder its effectiveness. First, corruption and judicial mafia, lack of professionalism, limited resource and facilities, limited legal knowledge, weak interagency coordination, non-holistic law enforcement strategies, cultural toleration towards corruption, emergency of cybercrime, and less social and cultural changes. Conclusion. In conclusion, criminal law is essential for maintaining public order, protecting individual rights, and ensuring justice. In Indonesia, it operates through a structured legal framework like the KUHP to address various crimes, but challenges such as corruption, cybercrimes, and resource limitation persist. Continuous improvement and collaboration among all stakeholders are crucial to strengthen the criminal justice system and uphold justice effectively. Thank you for your attention. That concludes my presentation on criminal law in Indonesia. I hope this presentation has provided you with a clear understanding of its importance and challenges. I apologize for any shortcoming or mistake in my presentation. Wassalamualaikum warahmatullahi wabarakatuh.